Alex here with part 26 of the My Docket series on child custody and visitation. As with my previous videos, I'll direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally closed. It cannot be reopened. My ex's parental rights have been terminated. Number two, the nutshell version of this series is that I want to provide my viewers with one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off in part 25 with the court's order denying my efforts to have my ex held in contempt of court, and today we're going to go into another court order that for the most part denies all of the, well, the relief that I'm requesting that's not opposed is wait a minute. The relief that I'm requesting that is opposed is denied, and the one thing that the court grants is the thing that my ex wanted anyway. So for the most part, it's an order denying as to my request to modify temporary child custody and temporary child support. This is something that I learned very quickly with respect to temporary orders, and it is something that only reinforced itself over time. As the years went on and I began to learn more and more about the court system and specifically how the appellate courts look at temporary orders, I began to really cement into the idea that there's just almost no point to challenging these, especially if you're unrepresented. And I talk a little bit about that dynamic in the videos, best interest of the parents, and even more importantly, self-representation bias. If you do have an attorney, sometimes for some reason they will modify temporary orders. I would like to say I don't know why this happens, but I did do a video on it and take a look at self-representation bias to get more into the details. Also, another good video that might help explain that is meta rulings. When it comes to temporary orders, they're extremely difficult to challenge, and what I mean by that is you can't, at least not in Nevada, you can't appeal those orders. You can file what's known as a writ petition, and I'm not going to go into detail as to what that is because I have a separate video dedicated to that. So definitely go ahead and take a look at the videos, temporary orders and also writ petitions. I'm going to go ahead and go into my mindset as I've done in the past with my previous videos, and in this case there were only a few days between this order denying and the last order denying. But what I can say is this: my spirits were low. When you're representing yourself, even if you have an attorney, in fact, even with a lot of legal experience, this will still happen to you, but when you're representing yourself, it's a whole lot more impactful. You will get an order denying, and you'll just feel like this whole system just doesn't care, and you're never going to get anywhere, and that everything you file is going to get denied. And it's extremely depressing, and it's, as I talk about in my previous video, it is connected to the fact that you have to wait so long to get that order. It's like tearing the band-aid off as slow as you possibly can. And it's just this torturous buildup. And so when you get that order denying, it's not just, I lost. It's the feeling, the emotions from all of that time that you were waiting, magnifying that loss. And it's the same thing for a victory. When you win a motion, all of a sudden you feel like you're the king of the world, you're going to win everything, the judge likes you. And there's a couple of videos out there where I explain, beware of these emotions, because both of them can really drive you down the wrong path. Losing can make you want to give up and not file things that would have been meritorious and you would have won. Winning can make you overly cocky and cause you to file things or take actions that are really damaging to your case because you feel like the judge likes you and you're going to keep on winning. So I did mention that I had videos in the general sense, but I didn't name them. One of the videos is getting explanations. Another video is relating to the judge. So all of that being said, I think now is a good time for us to go into what our district judge has filed. Here we have the court's order. Now, as I mentioned earlier, this is for the most part an order denying. The only concession the court gave me was that which my ex gave me. So I think, and I see orders like this all the time, I think that judges like this, not all judges are the same, but this specific judge, when he has an order that both grants and denies relief, for the most part, he'll just title it order. And he does this quite a few times. I think there may be one, maybe two exceptions where he actually titles it order denying this, and then like a semicolon, and then order granting that. Other judges have different styles, but in this case, because it's one of those mixed bags, he just titles it order. So I'm going to go ahead and scroll down. First paragraph, just like the previous paragraph, he identifies the briefs, the motion, the opposition, and the reply, including the specific dates as to when those documents were filed. I talked about why that's important in the previous video, so I'm not going to go over that again. Next paragraph, just like with the previous video, just like with the previous explanation, he is going into a summary of the facts. He's mentioning that we share a common minor child, and he is talking about the temporary custody situation. Next paragraph, it looks like, yeah, he did intend this to be a paragraph, he just didn't indent it. It is talking about what I filed in my motion. It's a brief summary of what I am requesting in my motion, which includes modifications to temporary child custody, temporary child support, and I'm asking the court to not include my entertainment bonus into child support. I explained this in part 18 of the My Docket series, so if anyone here is wondering, I mean, I went into the entertainment bonus and some of the problems with ordering or including volatile wage, I guess you'd call them factors. The problems with including volatile wage factors into somebody's child support is that it can change dramatically, and the person can just end up back in court trying to modify child support again. Now, this ended up working itself out later. The judge actually decides to nullify child support entirely, but I still caution my viewers when it comes to these types of income factors being included into your income, it's important to fight it, or at the very least to expand the duration of time that the court takes into consideration something like this, because it wouldn't be so bad if the court considered volatile factors like this and then didn't get so bent out of shape when somebody tried to modify child support a few months later. But it's not like that. The court will consider these volatile income factors, and then when you try to modify it because 3 or 4 months later you're not getting that anymore, the court gets ticked off. Well, with one exception. If you have an attorney. If you have an attorney, you'll probably be fine. If you don't, watch the video Self-Representation Bias. Scrolling down, summarizes the opposition. Scrolling a little further, court summarizes the reply, and the opposition and reply for the most part just reiterate the fact that my ex is consenting to that slight adjustment to the timeshare, and also goes over the Rivero decision, which I know I've talked about before throughout the videos that cover the briefs. But just to give everyone a recap here, my argument is that under the new case, Rivero v. Rivero, 2008, I want to clarify that for my viewers here. This does get changed in 2009, but it hasn't happened yet. But anyway, my argument is that in Rivero, you just need to have the child 40% of the time. My ex's argument is that it's not enough to have substantial timeshare with the child. You also have to show that you're taking care of the child, which is a little bit weird in my opinion because, and it's not just my opinion, ultimately the judge does agree with me, but it takes him a few months to come around. My opinion is that if somebody has the child 40% of the time and they're not taking care of the child, they shouldn't have the child 40% of the time. They should lose custody of their child. My ex's attorneys kind of cornered into this position where she cannot curtail my timeshare. So what she's trying to do instead is argue that even though I have all this time, I'm not really doing that much with him. It's a ludicrous statement because if that's the case, as I've already mentioned, you should modify child support. You don't want somebody to have the child 40% of the time and not feed them or clothe them or spend time with them. That's a problem. That's a custody problem. That's not something that you're just going to say, oh, let's make an exception to the 40% rule. He can keep the child all that time. He's just going to have to pay a whole lot of child support. So, and by the way, that's the whole point to arguing the custody designation, is that my ex wanted to receive more child support, or that she was afraid of paying child support. Let's see here. Scrolling. So the court actually cites the Rivero case. And the court just plucks one sentence out of the Rivero case and uses it to support his decision. I talk about this, I usually call it pretexting. This judge has done this before, and he will do this a whole lot more throughout this case. I do eventually nail him one time on an appeal, and that's right after he recuses himself. There are quite a few occasions where I could have gotten him, at least in my opinion, I could have had his decisions reversed on appeal for doing this little thing that he does where he just plucks a sentence out that kind of supports what he wants the conclusion to be. But that you're not going to see me nail him to the wall on that until all the way at the very end, where I finally start to win my appeals. And by then he's already recused himself anyway, so it's just one of those orders of his that gets reversed when he's already really gone out the door anyway, and I have a new judge. But this is something that I will continue to point out as I see it throughout my case, because I want my viewers to know, just because a judge plucks a sentence out of a case to support their decision doesn't mean that an appellate court is going to just buy that argument. You will still be able to have their decision overturned on appeal. And to give this judge a little bit of credit, he is using this line right now to rule against me, but within a few months he does come around and say, my ex's attorney, he tells her she's wrong and that the 40% timeshare is all that matters, and he does rule in my favor eventually. I think this judge's major problem can be summarized in the video meta rulings, and he's one of those judges who just kind of comes up with a conclusion and then finds whatever facts and law he can to support his conclusion. It's reverse logic. In fact, I have a video on it, but I don't apply it to judges, I apply it to litigants, and that video is conclusions before the facts. Same exact thing here. He decides what he wants to happen, and once he's come up with that decision, he will find the statutes, rules, and case law, and he'll pluck out the pieces that support his conclusion. And that's and by the way, I can't wait to get to that one decision that I get reversed on appeal, because that decision is the epitome of everything that I'm talking about right now. In fact, I've referred to it before as him twisting himself into a logical pretzel to make it work. And anyway, we're going to talk about that when I actually get to that point in this series. But for now, let's move on. Let's see here. He basically buys my ex's attorney's argument, and he follows up with Metz v. Metz, which has a it references statutes in Nevada that do discuss including all sources of income. He is right about this. The entertainment bonus and other bonuses and commissions and overtime, all of these things do need to be counted in the child support calculation. And so I'm not going to say that this is the same exact thing that he is doing now as before. In this case, he is correct. That bonus should be counted as income. And so in hindsight, I think I talked about this in part 17. I'm not fully sure now, either 17 or 18. It's the part where I talk about the filing of my motion. What I wanted to mention here is that the better approach would be to just ask the court to consider my income over a larger span of time, rather than try and argue that it shouldn't be considered at all. If you're in another state and you could do that, go ahead and do that. But in Nevada, even if a source of income is volatile, it still ends up being included. And so the best thing that you can do is stretch out the amount of time so that it averages out, so that it softens that that volatile bonus. And also because of the fact that it's so difficult to modify child support later on, especially if you're representing yourself. If you try and come back to modify child support because you're not getting that bonus anymore, sometimes, it may be in some states, oftentimes, the judge gets irate with you because you're back in court again. They don't necessarily care about the logic behind what you're trying to do. There's a whole lot behind all of this. I already cited all the previous videos that'll really get viewers kind of up to speed as to where I'm at. And so definitely take a look at all those videos, because I don't want to reiterate stuff that I've already covered. And the next portion here, the court adopts the stipulation of the parties. What the court is doing here is referencing my ex's agreement to modify the visitation schedule. So the court is saying that it will modify the visitation schedule consistent with my ex's agreement. And again, that's not really much of a victory for me, because she didn't even fight that. And honestly, you shouldn't ask for that in your motion. In fact, I talked about that in the video that covers the motion. If your ex wants something, your ex should request it in their motion. You shouldn't ask for it in your motion on their behalf. Don't do that. It gets really weird. And the last sentence here, the court is just stating that the temporary orders are subject to modification. And what he's talking about is just later on, he can just change them on a whim. And it's true. I talk about that in my video, temporary orders. Let's move on to, well, this is here is a certificate of mailing. The court is just indicating that the order is being mailed to myself and my ex. And let's move on to the next document. This here is my ex's attorney's notice of entry of order. As with my previous video, all this does is let my, actually I should clarify, I've already been notified that an order has been entered by the court. As you saw the previous document, the order was mailed to me, and the order was mailed to the correct address. So this notice of entry of order might seem totally superfluous, it might seem totally pointless, but as I mentioned in my previous video, there is another point to it that a lot of people, especially non-attorneys, do not understand, and that is that this document magically triggers the time limit to file an appeal. And I use the word magically because it doesn't make much sense to me. In my opinion, the court's order having been mailed to me should count as the notice. There shouldn't have to be another notice being sent to the parties, but for whatever reason, the Supreme Court of Nevada and the court rules, specifically the rules of civil procedure, indicate that, well, actually, it might be the rules of appellate procedure. It's either the rules of civil procedure or the rules of appellate procedure. They indicate that the notice of entry of order is the document that triggers the time limit to file the appeal. Whether or not the court has mailed the documents doesn't seem to matter. In fact, if you want to learn a whole lot more about this, please watch my video, Notice of Entry of Order, because I talk about it in great detail in that video. So this here indicates that it was mailed to me at the same exact address that the court actually mailed the order to me as well. And I believe if we move on, you can actually see the order itself. I'm not going to go, into any more pages on this document because it's just the same exact order that we already went over. And I just want to clarify to my viewers, if you would ever like to download these documents for yourself and scrutinize them, you can just go down into the description and you'll see links to these documents down in the description below. In this video, the court disposed of one motion. That was my motion to modify temporary child custody, temporary child support. The court denied that motion. Going into the aftermath, I didn't file any of these documents, so I incurred $0 in costs. My ex's attorney filed the notice of entry of order. That's a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex had an attorney who would have probably charged 15 minutes. I'm going to keep sticking to 15 minutes as these orders come out and they're very brief, and especially when their order's denied, because my ex's attorney doesn't really have to talk to my ex about it except to tell her, hey, this was denied. It's not the same as when an order is granted and the attorney has to brief her client on what it is that she's supposed to do now based on the order of the court. In this case, the order was denied. It wasn't very long, so I'm going to put it at 15 minutes. And the notice of entry of order, as I mentioned in my previous video, attorneys usually don't even touch those. It's the paralegal that prepares that. The attorney puts the signature on it, and that's it. And I'm going to put that one at 15 minutes too. So we're looking at a total of 30 minutes in attorney fees for my ex at a rate of $250 an hour. That comes to $125. As with my previous videos, if you have any questions, just post something down in the comments below, and I will see you guys next time.